thank you all for being here today. I know that there's a lot going on in the world, and so I appreciate y'all taking the time out of your schedule to join me. I would ask that you excuse me for looking like a grizzly bear, but as you know, all the barber shops are closed, so kind of is what it is till we get to go out in the world again. You might also notice that I'm standing. I'll be moving around a little bit. I read somewhere the other day that sitting is the new smoking. So I've adopted the standing desk, and if you haven't gotten one, I think you should check them out. They're pretty cool. It's a varied desk, so it goes up and down. I prefer to be standing if possible. So as I go through this, I got about 10 slides that I want to share with you. If you've got any questions, just write them down. You can ask me at the end, or I'll post my email at the end. And so feel free to email me or call me. I'd be happy to answer any questions. So with that, I'm going to share my screen with you and we will get started. Hey, Lynn, I unmuted you. Can you see my slideshow?
Yes, I can.
The top 10 estate planning mistakes?
Yes, as a matter of fact, I'm going to make it just a tad smaller so it fits.
Perfect, thank you. All right, so as you can see, this is the top 10 estate planning mistakes, or as I could say, 10 reasons you need a will, just to keep it simple. So first off, why do we do this? It's all about the family. And this is my crew. You can see my little guy on the left went fishing recently, and my wife in the middle. And you can see the reason I need a will on the right. I've got a 15-year-old that just started driving. So he's now my chauffeur, and it makes me feel all the much better about having a will with him driving me around. So mistake number one, not executing a will. This is kind of the reason I think that we're all here is what happens if you die and don't have a will? So I'm going to see if I can figure out how to share the estate code with you. And Lynn, do you see the estates code?
Yes.
Thank you. So this is the estates code in Texas. This is subtitle E, intestate succession. So basically, this is where the state tells you what's going to happen if you die without a will. If you have a will, it's just whatever's in the will, that's the way your property passes. If not, this is what you get to contend with. And none of us have enough time to read it right now, but you know, basically there's a bunch of different scenarios in here. If you're married, if you have kids, if you have kids from a prior marriage, if you don't have kids or a spouse, the state tells you all the ways that it's going to go. And as you can tell, it gets pretty complicated. And if you want to read that later, I'll be happy to send you the link. The probate court in Harris County in Houston attempted to make this simple by giving us this chart. This is another way to look at it. Let's see if I can share this. So this chart over here is the descent and distribution. And so they kind of break it down for you. If you have separate property, if you're a married person with children, these apply to you. So if you have separate property, the children take it subject to a life estate of the surviving spouse. The other property, the children take 2/3, surviving spouse gets 1/3. It breaks it down for community property, and then all the other scenarios that we were talking about. If you're single with no children, if you're a widow with children, these are all the different ways that your property could pass if you die without a will. And as you can tell, it gets complicated. So I'm just going to try and get back to my slideshow. All right, Lynn, are we good to go on the slideshow again?
Good? Yes.
Thank you very much. Sorry to ask you all these questions, but just want to make sure the technology works. Okay, so that's all the ways that your property will pass under the laws of Texas. Now, let's talk about what you have to do to get the property to those heirs. If you have a will, you simply file it for probate. It's a simple process. The court appoints an administrator and executor, and you move on with distributing the way that the will says. Now, if you don't, you basically do the same thing, file for probate, but there's some extra steps and expenses involved. Like you have to get the court to determine who the heirs are and enter an order. There's always an attorney ad litem that represents the heirs. If there's minors involved, you have to get a guardian ad litem for those minors. And that's if everybody agrees. If they don't agree, then you end up in a dependent administration, and the court essentially has to bless every move by whoever they appoint. So you have extra fees for the guardian, for the dependent administrator and their attorney. It gets very complicated and very expensive. And so that's really the point of having a will, is that not only do you get to dictate who gets your property, but it saves your family a ton of money on the back end by not having to go through a dependent administration. So we'll move on to slide 2. Oh, you see this perfect family here where they're all just getting along and happy. They would never dispute anything that anyone told them to do. Well, I've yet to meet this family, at least in the probate context. Literally every case that I've had where they didn't have a will, somebody got in a disagreement or a fight about something. So I would love it if every case was like this beautiful family on the beach here, but it usually doesn't end up that way. And so the mistake is that one of the reasons that someone wouldn't execute a will is that they think, my wife and kids get along fine, they'll just figure it out. Or my estate's too small to worry about, and the kids will just figure it out. In a perfect world, that might work, but as you know, we don't live in a perfect world. And so I think this is a huge mistake that someone thinks that, well, they'll just figure it out, because it usually doesn't go that smoothly. This is probably my least favorite of all of the mistakes that I'm going to show you today, because usually the person thinks that they've got it figured out because they actually did execute a will, but they executed a bad will for one reason or another. I mean, it could be a faulty acknowledgement. Usually we see it with, there's conflicting terms in the will. Like we had a case one time where the patriarch of the family, the granddad, died, and he had 5 or 6 kids, didn't like 2 of them, so he cut them both out of the will. Now the problem is he went to his local attorney, who was a friend of his, and she wasn't really well versed in wills, and so she thought that it'd be best just not to mention it. And that's really just not the best way to do it. I mean, if you're going to cut someone out of the will, you need to affirmatively say that, or leave them $1 or something like that, because the other bad part was he had about 15 grandkids, and she just forgot one of the grandkids. And so this just allowed one of the daughters that got cut out to contest the will, and they were tied up in litigation for almost 2 years. And between they got put into a dependent administration, and between the lawyer for the administrator and our fees and the contesting daughter's fees, this family ended up spending over $1 million and being in a fight with their sister for like 2 years because the guy executed a bad will. If he would have went to an estate planning attorney who would have known to mention that he was cutting out those kids and to document it and make sure that he had all the family info correct, I doubt they ever would have ended up in a contest. And if they would have, it'd have been summary judgment right off the bat. So this one always kind of breaks my heart, because the family or the mom or the dad or the grandpa, they did take the next step, they just didn't take a good step. And so I think it's important, whoever you're going to have do your will, to do your homework and make sure that they know what they're doing. Yeah, another place that this comes up is with personal property. You know, a lot of times they just leave the personal property to their kids or wife or whoever, but I oftentimes see that end up in an argument. You know, it could be down to grandma's china set or dish set or some silverware or whatever, a painting. I mean, you don't have to leave a memorandum saying who should get what, but it certainly helps because just like the previous slide, just thinking that the heirs are all going to figure it out usually leads to trouble. And that's something that we do counsel our clients to do. It's just it doesn't even have to be part of the will. What our will says is that if I leave a memorandum of personal property, I would like for my executor to honor that. And it just heads everything off at the pass. I mean, it's a good thing to do. You kind of know who wants what, and then people don't bicker as much if the person that's passed away actually left a note about it. Moving on to mistake number 4. Here's one that most people don't think about, especially young couples. Naming minors as direct beneficiaries. I would say the general term bequest over the years is, I leave everything to my wife, and if she does not survive me, to my children in equal shares. And that's fine, except for the fact that minors can't own property and they can't manage property. And so if you do have minor children, you've basically just set this estate up for a guardianship proceeding. Because a lot of the simple wills that you see out there, if you're just using a form that you got off the internet or that someone else gave to you and it has that bequest in it, to my children equally, they don't take the next step to appoint a guardian of the kids. And so you've got these kids getting property through the will, but they can't own it or manage it. And like the kid in the picture, even if they were 18, would you want them to? Would you want them to be in control of your estate? And also, I mean, just the burden of them having to manage it, is that what you would want? And so what we tell our clients who have minors is to leave it to them in a trust and appoint a trustee. And heck, even after they're 18, you might not want them to have it all. And so we've been writing in a lot of trusts in our wills where you leave it to the trustee of the family trust, and the kids get half at maybe 30 or 35, and then the other half at 40 or something like that, or you could go 30 and 35 depending on how much you trust your kids. But we've also been writing in terms in our wills where we give the kids incentive to work, and so you can leave it in trust and still incentivize them to be productive and to get a job. And so what we've been doing is basically allowing the trustee to distribute up to the amount of earned income for each year, for each kid for that year. And so they've got all this money in the trust, and if the trustee needs to, he could distribute it. But at the same time, they're out working, trying to make as much money as possible, and then you incentivize them to do that through the terms of the trust. And our clients have really been liking that because, you know, they want their kids to be taken care of, but they don't want them to have so much money that they can do nothing. And so that's been a hit lately, and we've been seeing good success with that. This is kind of a tricky one, but we do see it from time to time. So a residuary clause is the remainder of your estate. You make any specific bequest that you want, you know, to your wife, to your husband, to your kids, your grandkids. And then you've got the residual of to the remainder of my estate. It's a catch-all provision. And I'd say where we see it most is where this is left out is in a kind of a do-it-yourself or a homemade will, handwritten, and it usually comes up with someone that's, you know, a CPA or a bookkeeper or someone that keeps tedious records, and so they know everything that they have, and they want to leave it to a specific person down to the last fork. Now the problem is they don't include a residuary clause, and so what happens is down the road, someone in their family dies, and the person who wrote this will, their kids or grandkids inherit like a mineral interest out in West Texas or something. And so it would flow through grandma, but you look at her will, and there's no residuary clause. And so you end up having to file a lawsuit just to figure out who gets the property. And like I said, we usually only see this with handwritten or do-it-yourself wills where you could remove a clause just because you didn't understand it. But it's very important to have it in there, because usually something's going to come up that you might have owned or had an interest in that you didn't know. So I'll take a pause right there just for a second and check back in with my friend Lynn. Is the slide showing everything working for you?
It's absolutely perfect. So smooth. Thank you.
All right, good deal. We'll keep going. So these next few slides are about your overall estate plan, not so much the will, which is what we have been focusing on, but kind of the broader picture of everything that you own. And this one's pretty unique to families that have a closely held family business, because they may have their will and they may have their healthcare directives and everything ironed out, but nobody thinks, well, who's going to run the business after mom or dad, whoever's running right now, passes away? You know, it's just one of those things that you don't think, because the business just becomes synonymous with that person. But then that person passes away and there's no plan in place. And the bad part is that, you know, in a closely held family business, that's often the most valuable asset in the estate. And if you don't have a plan to run it, it either gets run in the ground or becomes a burden on somebody that didn't want it. And instead of having generations of income, you end up losing all the value of the business. And so what we tell our clients is, as part of your estate plan, we need to do some succession planning for the business. And the best way to do that, in my opinion, is through a company agreement, where everyone that's got a stake in the company agrees to it up front. You can hammer it out long before anyone passes away. And if you need to get some key employees involved, it kind of, you know, to run it after the current operator passes away, you can work that out with them on the front end. And it gives them incentive to stay around too, which is always a good thing. So this should be part, you know, it might not apply to everyone, but if it does apply to you, then it's very important to take care of on the front end. This next one is a big one, and it's getting bigger. I can't tell you how many times we talk to people about the cost of long-term care. I was looking at some studies yesterday, and it says the current annual average, and this includes in-home care or hospice care, but altogether averaged, the figure that they came up with was $65,000 a year for annual cost. And I read another study that said at 5% inflation in 2050, which is 30 years from now, it's going to be over 200,000. Some studies said as high as 300,000 a year. And that's for an individual that needs full-time, long-term care, which is astronomical. And really it just comes down to who's going to pay for it. And, you know, unfortunately, someone that's been very frugal their whole life and has built a really nice estate that they'd love to leave to their grandkids, they end up in a nursing home, and the nursing home eats up all of the assets, because we have a really nice Medicaid program in Texas. But for Medicaid to apply, for you to qualify for Medicaid, the limits are $2,349 a month in income and only $2,000 in assets. So you basically have to spend down to $2,000 to qualify for Medicaid. And now there's some different ways you can do that, and we do offer that here at the firm. So if you know anyone that's going through that situation, we'd be happy to talk to them and help. There's certain rules that you have to follow, and we kind of have a plan on how to get there. But essentially, you have to spend all your assets down. And so this is really important for an overall estate plan, to protect the assets that you've earned and saved your whole life. And there's a few ways you can do that. One is through Medicaid planning, like I was talking about, because you can move assets outside of a 5-year window from when you're trying. So as long as it was 5 years or more before you're trying to qualify, the state doesn't look at it. So you can move that into a trust or move it to different family members. There's different things you can do there. And the other thing is long-term care insurance, which it's expensive, but I think it's worth it. It's at least worth looking into, because like I said, the cost of long-term care is already outrageous and just getting worse. And I've got a really good friend that offers that long-term care insurance. So if anyone needs to talk to me about that, just email me and I'll give you his info. But as far as like for the overall estate plan, it's really important to think about it now rather than later. I've seen too many estates just get completely depleted by the nursing home fees before the state will kick in. Mistake number 8, failure to revisit your estate plan periodically. Now, our estate plans are designed to protect you for life. The minute that we send you the final draft, we think you're good to go forever, but it would be a mistake not to revisit that periodically so that we can make sure. You know, circumstances change, people have kids, people pass away, people retire, and they move their investments around. And so I would say every 5 years, just make a note to kind of look at it. And if anything has changed, to contact your lawyer just to make sure that it still works for you. Because, you know, if we went all the way back to, I think, slide 3, which was having a bad will, if it doesn't work, then it's really not worth having in place. And usually it's just a minor adjustment here or there just to make sure that everything still is in your best interest. This one's a big one and kind of a sneaky one. It pops up on people and no one really expects it. Failure to coordinate your non-probate assets. So the moment you die, you have what is a different entity is your estate. And your estate owns certain assets and has certain debts, and that's the reason we go through probate, is to figure all that out. But some assets don't go through probate at all. And a big one there is life insurance proceeds. That is like a payable on death bank account that goes directly to the beneficiary, does not go through your estate, is not an asset of the estate, and that's where it usually becomes a problem. And also, like I said, POD bank accounts, and then IRAs can't be owned by a trust. And so if you've left all of your assets to a trust, and one of those assets is an IRA, under the laws of Texas, it can't be owned by a trust. And so that's going to pass not through the probate process, but to your beneficiaries that are named on that IRA. And so what becomes an issue is that you could unwittingly disproportionately benefit some heirs over others. So if you really wanted to leave, you know, an equal amount to certain kids, but one kid was on a life insurance policy because he was your first kid and you never changed it and put the other one on there, that kid could end up with $1 million or more that his brother's not going to get a part of. And then, like I said, it's also not a part of the estate. And so you would lose that money as an asset of the estate to pay for debts of the estate. We've seen that too, where the guy was still working when he passed away, made a bunch of money, had a severance package, ended up owing about $300,000 in taxes, and had $1 million life insurance policy, but it didn't go into his estate, and neither did his IRA. And so the estate was short on cash to pay the taxes. And so then you get left a lot of times with hard assets like, you know, cars and trucks and ranches or whatnot, and you have to liquidate those when the decedent really wanted that to be part of his family forever. And so you really just need to sit down with your lawyer, your financial advisor, and make sure that you have it written down and understand what assets are going to go to your estate and what assets are not going to go to the estate, and make sure those are going where you want them to. In another case that we had recently, the guy left a trust, and it was an incentive trust like we were talking about, where he wanted his kids to work and he only wanted them to get up to the amount that they earned. Well, both the kids ended up splitting a life insurance policy. It was about $1 million. So they had $500,000 right off that the dad wanted to be in the trust, but didn't end up there. And then on top of that, his IRA had to be owned by them and not the trust. And under the laws, you have to take minimum distributions every year, and all of it within 10. So they were getting whatever they were supposed to get from the trust, plus the $500,000 they got from the life insurance, plus a minimum distribution of another $60,000 a year, which is, you know, great for the kids, but nothing like what the decedent wanted to happen with his will. So you really just need to balance those assets and know where they're all going to go. So this brings us to the last mistake, but I think probably the biggest one of all. This mistake causes a lot of heartache with families young and old, and that is executing a will but not healthcare directives or a power of attorney. And so the reason that we bunch everything together for an estate plan is that you need them all. If you make this mistake, it's essentially like planning for your death but not planning for your life, because incapacity does happen. I was reading a study yesterday, 20% of people are going to face some sort of extended incapacity before they reach retirement age. And that number goes up to 50% at age 65. And so the problem is that you get in a car wreck or work accident or a pandemic like we've got going on right now, and you're in a hospital bed and you can't communicate. Well, who's going to communicate for you? I mean, most of these hospitals and doctors are pretty strict about who can make decisions for you, especially, you know, end of life care. I mean, who's going to make that decision? You should be able to make that decision if you have a healthcare directive. And same thing with paying bills and operating bank accounts. If you have a durable power of attorney in place, you've already named the person that you trust. And HIPAA authorization, all of that comes in an estate plan, and all of it it's extremely important, because, you know, if you were to suffer some sort of incapacity, I mean, your family is already going through an emotional time. It's tough on everyone. And then not to be able to get the care you need without having to petition a court for a guardianship of the person it's really heartbreaking. And so that's why we talk about like an estate plan. Everyone knows about the will. Everyone knows they need a will, but no one thinks about incapacity during life. And it does happen more than we would like. And so this is probably the biggest mistake that I see, is that people will take care of the will, but for the extra money that it's going to cost, they don't want to do the full estate plan. I can't stress enough how important that is. Which brings me to the last slide. What's your next step? So you're all here because you decided to get this done, and I'm here because I've seen this tear too many families apart. I feel like that Farmers commercial, I'm sure you know the one I'm talking about, where he says, we know a thing or two because we've seen a thing or two. And I really just don't want to see that happen to you. And so, I mean, the biggest reason that people don't have a will is because they just procrastinate. You know, it's human nature. We all do it. And as far as I can tell, there's 4 reasons that we procrastinate. One is just fear of failure. We don't think we can get it done. Or fear of the unknown. We've never done it. And that's where we come in. We take care of that for you. You don't have to fear failure or the unknown, because we're going to show you how to do it. We're going to do it for you. And then the third reason is time and energy. You know, you can't block off enough time, and you just don't feel like giving it the energy that you need. But we take care of that for you too. I'm gonna copy and paste the link here in a second into the chat, and I want you just to click that link, which is going to bring you to our intake form, just so that you see how easy it is. Let me see if I can figure this out. I mean, honestly, it'd probably take if it took you more than 15 to 20 minutes, I'd be surprised. That's really all the info that we need to get started on your estate plan. I mean, we will meet together, whether it's video conference or after this shelter in place is lifted. We'd love to meet you in person. But if you see in the chat where I copied that link, Alex, do you see that link in the chat?
No, I don't.
You should be able to click on a group chat.
Yes, I did. Has for everyone, but I don't see
Oh,
it.
wait. Yeah, that was a private message. Hold on.
Oh, there you go.
Yeah, if you copy that link and paste it into your browser, I'm not asking that you fill it out, but I'd like for you just to see how easy it is. Like that's what we boiled it down to. That's the vital information that we need to get started. And then we'll get together after that. After we get that initial information, we'll get together and talk about what your specific needs are. But I welcome you just to copy and paste that and just take a look at it when we get done with this call. And I'm also going to give you my email address. You'll be getting a couple of emails from me, but just so that you have it. I don't know why it went right there. I'll follow up with you with my email address. I think you can see it right there, but it looks like it put on the end of the intake form. But I'll follow up with my email address and my phone call so that you've got my my info, and I'd love to hear from you and answer any questions that you've got. Getting back to procrastination, the fourth reason that we do it is the cost. Everyone thinks it's too expensive. You know, you don't want to spend the money now. You'd rather just save the money. And I'll have a full price sheet for you later, but I'd say on average, I mean, there's a bunch of different things we can do, but on average, it's about $1,500 for an individual estate plan, and just under $3,000 for a couple. We give you a bit of a discount if we're doing both of them. And we, like I said, some cost more, some cost less, but that's our basic price. And we do take credit cards, and if the only thing that's holding you back is the price, we can also work out a payment plan with you. But the thing that I can't stress enough is that, you know, people think they're saving money by not doing a will or an estate plan, but you're really not saving any money. You're really just kicking that can down the road. And in the end, every time I've had an intestate case, or especially one where there's a contest of the will, it ends up costing the family so much more in the end that it really just makes all the sense in the world to do it now. And so if I can answer any questions, like I said, I'll send you my email and my phone number, and I've sent you the link. I hope you take a look at that. Just email me or call me. I've always got time for you, and I'd love to talk to you. And I really appreciate y'all joining me today, and I hope that you have a beautiful day. I'm going to unmute all. So if anyone has a question, go ahead and ask it. I'm ready. And hopefully I didn't bore you all to death.
No.
All right. Well,
I have a quick question. Sorry if I was waiting to let other people. I came in late to this meeting. My name is Alexa. Quick question. Did you cover things on like kind of the digital assets that people have and kind of providing things?
you mean like copyrights and patents and whatnot?
Well, no, actually what I was thinking was more like online accounts and various things.
No, we didn't talk about that today, but I'd be happy to talk to you about it. Do you have any specific questions?
Maybe we can take it offline because it's probably more a broader question, but I just wanted to make sure if you talked about that, that's what was something I'm really keen to talk about as well.
Okay,
So I'll follow up with you though, Eric.
Okay, yeah, follow up with me. I'd love to talk to you about it.
Okay.
And no, I don't have any direct question.
Okay.
So,
Well, if you come up with anything, just email me or call me.
right. At this, just at this time, I don't. So I did appreciate your, concerns that you expressed, and also you did it in a very easy to follow along with format. So thank you for that.
Well, I appreciate
And,
that.
Yeah. So at this time, then I'm going to leave the meeting. Thank you.
Okay, well, I'm gonna close it down. Thank you all for joining. And as I said, give me a call or email with any questions you've got. We'd be happy to answer them.
Okay.
Thanks a lot, Eric. Thank
All right,
you.
Have a great day.
Thank you.
You too.